Regulations of the hearing. In order to ensure the public order, security, and the effective functioning of the proceedings during the hearing on 4th of December 2008, the President of the Pretrial Chamber has established the following regulations. 1. All persons who wish to attend the hearing shall appear on the premises of the extraordinary chambers in the courts of Cambodia before 9 a.m. on the date of the hearing. 2. All cameras, camcorders, tape recorders, and loudspeakers are prohibited inside the room, except as otherwise ordered by the pretrial chamber. 3. All persons are prohibited from smoking, bringing food or drink inside the courtroom. 4. All weapons are prohibited inside the courtroom. 5. Cell phones may not be used inside the courtroom. This includes the use of cell phone cameras and audio recording by cell phone, which is strongly prohibited. 6. Moving, changing seats, or walking freely inside the courtroom without permission is not acceptable and strongly prohibited. 7. All persons are prohibited from shouting or making loud sounds inside the courtroom. 8. All persons shall communicate with the security staff of the ECCC if they need to enter or exit during the course of the hearing. And 9. Persons under the age of 18 are not permitted to enter the courtroom. The President of the Pretrial Chamber may take direct action against those persons who breach these regulations or commit any illegal activity against the proceedings as a result of the actual acts or offenses committed. Phnom Penh, 2nd of December 2008, President of the Pretrial Chamber, Prak Kamsan. The court, all rise please. Please be seated. Reporters, please leave the room. In the name of the Cambodian people and the United Nations, today, the pretrial chamber of the extraordinary chambers in the courts of Cambodia declares open the hearing on the appeal against the co-investigating judge's order on translation rights and obligation of the parties in the criminal case dated 19 June of 2008, in the criminal case file number 002-19-09-2007, ECCC OCIJ, in brackets PTC 11, dated on the 19th of June 2008, in which the charged person killed Samphan alias Ham, Cambodian nationality, male, born on the 27th of July 1931 in Rumchek Commune, Rumdul District, Svay Rieng Province, Cambodia. Pre-arrest address: Kon Klong Village, Otawao Quarter, Palin District, Palin Town, Cambodia. Father's name Kieu Long, deceased. Mother's name Pao Kong, deceased. Is charged with crimes against humanity and grave breaches of the Geneva Conventions of the 12th of August 1949, being crimes set out and punishable under Articles 5, 6, 29 new and 39 new of the law on the establishment of the extraordinary chambers in the courts of Cambodia, dated 27 October 2004. Defense co-lawyers Mr. Sa Sowan and Mr. Jacques Verges. Civil parties represented by 8 lawyers: Mr. Hong Kum Soon, Mr. Lau Chun Thi, Mr. Ni Chandi, Mr. Kung Pisai, Mrs. Zilk Strudwinsky, Mr. Yong Panat, Mr. Kum Meng Ki, and Mr. Martin Chakwin. The greffier, are all the participants present at the hearing?
Mr. President, everyone is present.
Present at today's hearing are Mr. Prakum San, President, Mr. Roban Downing, Judge, Mr. Naito, Judge, Mrs. Katinka Lahus, Judge, Mr. Hood Wuti, Judge, Mr. Pan Pixley, Reserve, Judge. Greffiers, Mr. Chun Sokresai and Mrs. Anne Mary Burns. Co-prosecutors, Mrs. Jia Liang and Mr. William Smith, Deputy Co-Prosecutor. I would like to inform the hearing that after every 1 hour and 15 minutes, we shall have a 15 minutes break. The charged person, please stand up. What is your name? Could you please press on the mic or make sure that your voice is heard? Have you got any alias name?
When I was working in the resistance force, my name
How old
was Ham.
are you?
Now I am 77 years old.
What is your nationality?
Cambodian.
Where were you born?
I was born in Svay Rieng Province, in Rumdul District, Rumdul Commune, Rumchek Commune.
What was your occupation before you were arrested?
Pre-arrest occupation, none. I lived by my wife support.
Where did you live before you were arrested?
Pre-arrest address in Ottawa quarter.
What is your father's name?
Kiu Long.
What is your mother's name?
Po Puong.
What is your wife's name?
Ren.
How many children have you got?
4 children.
Have you asked for any lawyers to defend you?
Yes, I have co-lawyers, Mr. Sosavan as the national lawyer and Mr. Jacques Vazes, the French lawyer.
The third person in this occasion, I would like to inform you of your rights. Pursuant to Rule 21(1)(d) of the Internal Rules, you are presumed innocent as long as your guilt has not been established. You have the right to be informed of any charges brought against you. You have the right to be defended by a lawyer of your choice, and you have the right to remain silent. Please be seated. I would like to invite the reporting judge to read the report of examination.
My respect to your honors, members of the bench. I would like to read out the report of examination. Criminal case file number 002 1909 2007 ECCC in bracket PTC 11. Report of examination abridged. A. Introduction. Pursuant to Rule 77.10 of the Internal Rules of the Extraordinary Chambers in the Courts of Cambodia, hereinafter referred to as Internal Rules, the President of the Pretrial Chamber has assigned Judges Nathol and Katingkal Lahaus to set out the details of the decision against which the present appeal is lodged and of the relevant facts of the case file. Kiu Samphan, alias Ham, male, born on the 27th of July 1931 at commune of Rumchek, district of Rumdul, province of Swirien. Kiu Samphan is under investigation for crimes against humanity and grave breaches of the Geneva Conventions, being crimes set out under the law on the establishment of the extraordinary chambers in the courts of Cambodia, hereinafter referred to as the ECCC law. Kiu Samphan is represented by co-lawyers Mr. Sosavan and Mr. Jacques Vazes. B. Co-investigating judge's order on translation rights and obligations of the parties. On the 19th of June 2008, the co-investigating judges issued the order on translation rights and obligations of the parties, hereinafter referred to as translation order, addressed to all of the charged persons and parties in the case file, among them Kiu Samphan. In this order, the co-investigating judges considered various rights of charged persons in relation to the parties' request for translation of documents. These rights included the right to be informed of the charges against them in a language that they understand, to have adequate times and facilities for the preparations of their defense, to equality of arms, to examine evidence against them and evidence on their behalf under the same conditions. And to have the free assistance of an interpreter if the charged person cannot understand the language used in the court. The co-investigating judges also considered the charged person's right to a trial within a reasonable period of time. C. Khieu Samphan's appeal against the translation order and the Office of Co-Prosecutor's response. The co-lawyers of the charged person appeal the translation order and request that the pre-trial chamber 1. Set aside the co-investigating judge's decision denying the request for translation. 2. Note the violations of the charged person's rights as a result of the absence of translation. And 3. Immediately and unconditionally release the charged person. They do so on the grounds that the co-investigating judge's decision lacks a legal basis and that the charged person's rights have been so violated that it is no longer possible to uphold his rights to a fair trial. The co-prosecutors respond that the present appeal is inadmissible and is moreover substantively devoid of merit. In their view, the charged person is not entitled to any consequential relief, including release. D. Particular arguments of the parties. In their submissions, the parties dispute the following issues, in particular: whether the appeal is admissible, whether the co-investigating judges have the jurisdiction to issue the translation order, whether the translation order sufficiently takes into account the specificity of the ECCC as a court modeled in the civil law system, whether the charged person has a right to translation of documents into the language of his lawyer, whether the translation order provides for the translation of the types of documents necessary to uphold the charged person's rights to a fair trial. Whether the parties can be obligated to collaborate in the translation process according to the measures set forth in the translation order, and whether the charged person is entitled to be released. I wish to inform the members of the co-prosecutors as well as the defense and publics that this report is a brief summary of the examination. So, Phnom Penh, the 2nd of December 2008, co-reporters.
Charged person, please rise.
opportunity to make some preliminary remarks, and after this to make a preliminary request. On behalf of the civil parties, I would like to make these remarks on the right of civil parties to present brief oral observations in this appeal hearing.
Could you please,
The co-lawyers...
excuse me, could you please wait?
Nina.
Do you have an application that you wish to make to the court, or is this a statement that you are wishing to make?
It is a preliminary request, and I will give the grounds for this request. And I don't see any rule prohibiting to introduce a preliminary remark. It is not on the translation issue.
I wish to know whether you are making an application rather than making merely remarks or observations. Is this an application that you are making?
Can you, excuse me, can you repeat? I didn't get it.
I'll repeat. Are you making an application to the court, or are you making remarks?
Both. May I continue? Thank you. The co-lawyers of the civil parties did not respond by a written submission to the appeal of the defense against the translation order of the co-investigating judges within the deadline, nor did they submit a written pleading. Due to limited resources, the co-lawyers are not in the position to address all appeals of the defendants. Rule 77.4 provides that the parties must file their written pleadings before the hearing with the greffier of the pretrial chamber. In addition, pursuant to Rule 77.10, the lawyers for the parties may present brief oral observations during the hearing. There is no provision as to whether the obligation to file a written pleading is a prerequisite to make oral observations. Looking at the guiding Criminal Procedure Code of Cambodia, Article 259 is clear that only the prosecution must file a written submission, while the parties and their lawyers may submit their written briefs before the hearing. According to Article 260 of the Criminal Procedure Code, the lawyers of the parties are allowed to present their observations in the hearing. To conclude, the CPC, the Criminal Procedure Code, is on this point clear and grants the lawyers the right to speak in the hearing regardless of whether they have submitted a written statement in advance. Hence, the key question is if the rules may restrict the rights of the parties that are granted by the Criminal Procedure Code of Cambodia. And what is the hierarchy of these two procedural codes? The solution might be found in the agreement between the United Nations and Cambodia and the implementing ECCC law, which is to be considered as the statute of the court. Pursuant to the agreement between the UN and Cambodia and the implementing ECCC law, the applicable procedural law at the ECCC is the Criminal Procedure Code of Cambodia, in force since August 2007. Only where Cambodian law does not deal with a particular matter, or where there is uncertainty regarding the interpretation or application of a relevant rule of Cambodian law, or where there is a question regarding the consistency of such a rule with international standards, guidance must be sought in procedural rules established at the international level. The agreement and the ECCC law are very clear as to which law is applicable. That is to say, the Criminal Procedure Code of Cambodia being the very primary source. Internal rules that have been made by a plenary of judges are deliberately not mentioned. The internal rules are neither approved by the National Assembly, nor has the plenary any authority to adopt procedural rules, a difference when compared to all other international and internationalized tribunals. The character of these internal rules, if at all held valid, must be considered as a decree law that in the case of conflict between the internal rules and the Criminal Procedure Code of Cambodia must be resolved by the rule lex superior derogat lex inferior, which means that a higher ranking provision prevails a lower ranking provision. Thus, the co-lawyers of the civil parties submit that they have the right to give their oral observations according to the CPC, the Criminal Procedure Code of Cambodia, even if they have not filed any written pleadings in advance. As the appeal of the defense against the translation order is not limited to translation issues but amounts to an unconditional request for release because of the alleged violations of the defense's rights, the interest of the civil parties is seriously concerned. Therefore, the co-lawyers of the civil parties request the pretrial chamber to allow the civil party co-lawyers to submit their observations on the appeal of the defense. Furthermore, we request the pretrial chamber to decide on our request immediately in order to protect the rights to be heard in this hearing, to protect this right of the civil parties and their lawyers. Thank you.
About other members of the parties, do you have any comment on the request by the civil parties lawyers? Prosecutors?
Good morning, Your Honours, Learned Defence Counsel, civil parties. Your Honours, this issue perhaps raises the problem of being caught by surprise on the day of a hearing. And very much many of the rules that have been put in place have been to enable this court to run efficiently and fairly. The problem, of course, of parties bringing submissions to the court on the day without Your Honours being made aware, nor the defence, nor the prosecution, is it creates an inefficient proceedings where parties are unprepared to be able to deal with that particular issue. Having said that, it's admitted that if this was an issue that was required to be raised by the civil parties, that it should have been raised in advance to us so that we could prepare appropriately. But perhaps the submission by the civil parties raises 2 points, and that is, one, the legality of the ECC rules in general, and two, whether or not the civil parties have followed the procedure that the rules cover, and secondly, the orders of the pretrial chamber in relation to civil party submissions. Obviously, for proceedings to run efficiently, parties need to know the rules. If we know the rules, we can follow them, and then the pre-trial hearings can run smoothly. As Your Honours have heard, the civil party lawyers in this case have not followed the rules. We don't quite know why they haven't done so, apart from the fact they say they don't have enough resources. I think it would have been quite appropriate for them to file something brief, taking into account their resources, and to have them put forward to the defence and the prosecution and the trial chamber the substance of what they've had to say. The fact that they say they don't have a wealth of resources, which we all don't, really I don't think is any excuse to not put something brief to the pre-trial chamber. As far as the rules and regulations, the civil parties are correct. Rule 77.4 requires that parties that want to make submissions in an appeal hearing need to file their responses. The prosecution did, and the civil parties chose not to. And we're to file in accordance with the practice direction, that's 8.3, within 15 days. If the defence couldn't do it, sorry, the civil parties couldn't do that within 15 days, they could have filed an application under Article 9 of the practice direction saying, look, we're late, we didn't have enough resources, but can you accept our submissions now? They chose not to do so, bearing in mind the 4 or 5 months has passed since the filing of the papers. I think it's important to know that the prosecution strongly encourage and welcome and invite the civil parties to this process, because that is what makes this process at the ECC so unique. However, there needs to be some sort of certainty with the process. As far as more particularly, the civil parties are aware of Your Honour's position on the filing of observations and appeals, particularly in relation to civil parties. Your Honours have made clear in your decision on the 20th of May 2008, entitled Directions on Civil Party Oral Submissions during the hearing of the appeal against the Provisional Detention Order. That was in relation to Yang Tarit. And if I can remind Your Honours of paragraph 4 of that order, it states, with reference to fair trial principles, a key consideration is that the defence should be aware of the contents of civil parties' oral submissions in advance of the hearing. The pre-trial chamber notes the increased number of civil parties and their different positions. The pre-trial chamber has furthermore taken into consideration the technical nature of the written pleadings of all parties, including the civil parties in this appeal. So, in addition, Your Honours, to the rules, Your Honours have clearly stated to all parties, but particularly to the civil parties, that in order for these proceedings to run smoothly, they should at least give some notice. I don't think the prosecution and defence would be requiring anything elaborate because of resources, but something so that we can respond to whatever they may have to say, unlike what we've been able to do today. The next point perhaps is the legality of the rules. Clearly they haven't followed the rules and they've been in a position to. As far as the legality of the rules, Your Honours, in your decision on the 26th of August 2008 in the annulment appeal, you have basically stated that the rules are legal and are reasonable in the sense of trying to make Cambodian law apply to the very unique circumstances of these very complex cases at the ECCC. My learned colleague, the civil party lawyer, referred to that when she said the international practice and rules can be followed if there's some sort of uncertainty of how you could apply normal Cambodian procedural law in this court. Because of the nature of the complexity of proceedings, certainly a question of efficiency by giving parties notice of what other parties are going to say is quite appropriate. Perhaps a different situation in a national Cambodian case where the complexities arguably are a lot smaller and issues can be dealt with perhaps more temporaneously as they arise. So, to close, Your Honours, the prosecution strongly encourage the participation of the civil parties, but it's important that we all follow the rules, prosecution included, to ensure that the proceedings run smoothly and fairly. Thank you.
The defense, please.
Your Honours, the pre-trial chamber and all people who are observing the hearing today. I am the co-defense lawyer, Samphan, the defense lawyer for Samphan-English-I. I am now challenging the intervention of the civil party lawyers because I have just observed the remarks of the co-prosecutors that according to Rule 77(4), the civil parties claim that they were not notified, that they could not manage to file their submissions in writing. And the co-defense lawyers, civil lawyers here would like to raise this matter in the hearing without notifying any one of us in advance. So as the international co-lawyer stated, you already referred to civil code of Cambodia, and I think you may probably be misguided. If you look at the rule, the criminal code of 1956, during the investigation stage, these acts shall be regarded as confidential. And now you look at my client, his detention has been extended to another year. And I think these victims have been provided significant space or rights to claim their rights. But now, if you look at the position of my client, as the pre-trial chamber already raised, that my client shall be presumed innocent unless there has been the final judgment from the bench, the court. So he is under investigation, and as a co-lawyer in our Cambodian court and criminal procedures, I really demand that the co-investigation proceed the case more expeditiously so that my client should not be further detained with undue delay. That's why he remains innocent. That's why now I understand your suffering, and of course you have been given so much time already to defend, but if you raise this matter now and I have not been given any notice, then I have not been in a good ground to challenge your remarks or requests, and I think it's, that's all.
How about the civil party lawyers? Do you have anything to respond?
Only briefly, in response to the prosecution, of course, the civil parties follow, and I would say, the rules, the provisions of the proceedings before the ECCC, but these provisions that gives the guidance is the Criminal Procedure Code, and in particular in the case of conflict, and not the rules that restrict civil parties' rights. That's all. Thank you.
If I will ask one question. Have you given notice of what you intend to say to the defense and to the prosecution?
Do you mean the preliminary remark or the statement on translation issues?
Of the substance of what you are intending to say?
No.
The pre-trial chambers would like to retire for deliberation for 10 minutes.
The decision of the pre-trial chamber. 1. The pre-trial chamber noted the remarks raised by the civil party lawyer that the internal rules cannot be applied. The pre-trial chamber has decided on the 26th of August 2008 in the annulment case of the charged person Noon Chia, extensively reasoned that the internal rules are applicable before the ECCC. This decision has not been reconsidered by the pre-trial chamber. The oral submissions made today by the co-lawyers for the civil parties do not give reason for the pretrial chamber to reconsider. The PDC therefore finds that the internal rules are applicable. 2. The pretrial chamber notes that the co-lawyers for the charged person filed their defense appeal against the decision to deny the request for translation of Q. Samphan's case file on the 22nd July 2008. The co-prosecutors responded on the 28th of August 2008. The lawyers for the civil parties did not file a response to the appeal brief. On the 4th of November 2008, the pre-trial chamber rendered its decision on Q. Samphan's request for the public hearing, allowing the request and scheduling the hearing. 4. In its decision on civil party participation in provisional detention appeals of 20th of March 2008, the pre-trial chamber highlighted the importance of giving prior notice to the charged person of the arguments to be made orally during a hearing. Referring to fair trial principles, the pre-trial chamber decided that civil parties should file submissions in order to make it possible for the charged person to respond to the issues to be raised. This was also the basis for the pre-trial chamber's directions on unrepresented civil parties' right to address the pre-trial chamber in person. Of the 29th of August 2008, in which the chamber directed that any unrepresented civil party claiming the right to address the pre-trial chamber in person at a scheduled hearing shall make a written request explaining the content and the relevance of his or her proposed submissions at least 10 days prior to the hearing. 5. The pre-trial chamber finds that the lawyers for the civil parties have had sufficient time to express formally their intention to present oral arguments at the hearings and to provide adequate notice of the nature of their submissions. As this has not been done, the pre-trial chamber will not hear oral arguments from the lawyers for the civil parties during the hearing on the substance of the appeal brief. Therefore, the pretrial chamber refuses the co-lawyer of civil party to submit orally. This decision will be written and included in the case file.
The charged person, please stand up.
Mr. Samphan, would you like to make a statement related to your appeal, or would you like your lawyer to speak on your behalf?
I would like to ask my co-lawyers to speak on my behalf.
Thank you. Be seated. We allow you to sit at a different location if you wish to ask so. The lawyer?
Thank you, Mr. President, for allowing me to sit on the side bench.
Some until
I would like to invite the members of the defense to make a brief observation. You have 1 hour to make this observation, please. So please divide the time among yourselves. You have 1 hour to make your brief observations, please.
Your Honors, the pretrial chamber bench and the audience. I would like to express my thanks once again to the President personally for allowing me the floor. And I would like to inform the President that I already submitted a request to release my client immediately, because the decision to make the decision on such request is subject to the President's decision. And I would like to also submit that the provisional detention is irregular. I would like to also, I submitted an appeal against the provisional detention because there has not been any proper translation of the papers or the documents, and we are waiting for the decision. And without having addressed this appeal yet, then the pretrial chamber, sorry, the judges actually extended the provisional detention on my clients. And my client has been presumed innocent. He is a suspect. And in this hearing, I would like to only raise the matters related to the translation of the documents related to these arrest of my client. And as a co-national lawyer and my international co-lawyer, what we want is justice for our client. So we are together on the same boat. And I would like to submit to the pretrial chamber bench that there are some irregularities, and I would really need to make sure that all documents related to the criminal case regarding the arrest of my client are translated into French. And my co-lawyer, my colleague will take over from my floor next. And when it comes to the request for the translation from French into Khmer, and I can see that there are some substance of the translation is hard to understand. I do not really point the finger to the translators, but I know that some translators are not people who have good background in legal matters. And I think that in Cambodia, even so far, we have not got a legal dictionary as yet. So any interpretation in the translation itself is not sufficient, or that's why I do not really press on this matter for more, but I would like the pretrial chamber to pay more attention on the translation matter, because the legal translation of the text is really difficult to understand. And in the special chamber, or we call extraordinary chambers in the courts of Cambodia, there are 3 official languages, Khmer, French, and English. But unfortunately, some related languages are not translated into Khmer. For example, now I'll give you an example. Until July, some documents that the co-prosecutors have been given in English are not available in Khmer. Therefore, I, the national co-lawyer, find it very difficult to defend my client without properly understanding the Khmer language. I therefore would like to remind you about the translation again, and it is very important that justice is done by way of understanding the substance of the case. And I would like to submit to the pretrial chambers. Also, I know that the bench also would like to make sure that translation work is done expeditiously, and I want my client to be released provisionally, and only when my client guilt is found that he should be further detained. That's why I think that's all what I would like to comment. I would like to give the floor to my colleague to continue. Thank you.
Mr. Zagrakzes, the floor is yours.
Fonctions, mais aussi avec la fermeté que doit avoir un avocat de la défense pour défendre.
We have to take a very strong position when it comes to defending our clients' interests, and specifically when it comes to defending our client's interest. My client has just reconfirmed his gratitude for my services when you had recommended that he change defense counsel, which is somewhat unusual. I have reviewed the case law of international law, and in the last 15 centuries, not a single court has ever asked a defendant to change defense counsel, and I believe that we are now in a situation where the ECCC will forever be remembered for this unusual request. But I want you to know that I will do my utmost to continue to defend my client to the best and utmost of my ability. The decision of the pretrial chamber, Mr. President, Your Honors, came at a time when we had requested the translation of all of the documents. There are 60,000 documents which exist in Khmer, and only 2.5% of these documents have been translated into French. And you felt that my request was excessive. And yet, Mr. President, as I was listening to you a few moments ago, you were saying that this court was speaking on behalf of the United Nations. And my position is that of the United Nations and that of the Secretary General of the United Nations, who in a meeting on the 12th of October 2004 stated as follows in front of the General Assembly, who was confirming the position of the Secretary General. The document I am referring to is almost completely in Khmer, and only a small portion has been translated. And a tremendous task is still ahead. The Secretary General acknowledges that there is a tremendous task ahead, but he does not say that this should not be done. I think that one of the tasks that we need to take into account, I'm sorry, you have just said something? You have asked me to slow down. Yes, thank you. I have taken note of your request. So the Secretary General has said that the judicial investigation cannot fully begin until the translation. So the Secretary General of the United Nations has said what I have been saying from the very beginning. On behalf of the United Nations, you are saying that things should be done, and the Secretary General has said that everything should be translated before the judicial investigation can begin. Perhaps you could recommend to the United Nations that they change their Secretary General, because then I would be in good company. So why have these translations not been done? These are the answers that I've been given. There's no money. We are talking about French. France is the second contributing nation to this court. France has given millions of dollars, and just a few months ago, a French minister came here, and he left an additional million, and translating 60,000 pages does not cost $1 million. So why hasn't it been done? Why has it? What do people tell me? I am told that there are other translation that is required. And I have seen, for example, the beautiful posters asking the people to trust the court have been done. So I think that when the France gives money, it's not to ensure that posters are translated. I have heard that judges have gone through the area, and that it has been encouraging civil parties to apply. So I am saying that the money that the France has given was mainly to translate things into French and not to allow additional civil parties to come and apply. And basically money has been used in the manner which it was not intended. So as a lawyer before this court, as a Frenchman appearing before this court, I have the right to ask you, what have you done with this money? $5 million, and you can't translate 60,000 pages? And yet the defense counsel is being asked to consent to a violation of his rights. One argument that is being used is that we need to have an expeditious trial in the client's interest. I agree with this principle. I agree that it's important to proceed in an expeditious manner, but we need to proceed in a fair and expeditious manner. So you are saying that we should proceed expeditiously at the cost of fairness, and I don't think that we should proceed expeditiously in a manner that is unfair. And so the problem that we are facing today is as follows. Is it possible to have a fair and expeditious trial when the final submissions that the prosecutor has been made has not, the supplementary submissions filed by the prosecutor have not been translated. We are talking about the supplementary applications, and that document has not been translated into French. We are being asked to agree to the following. We're being asked to agree with this situation. Mr. President, you have stated a few months ago that the accuser needs to be informed through his defense counsel, but if the defense counsel is not given the supplementary submissions by the prosecutor, then we can just manage. He can go ask, go speak to the registry and manage in English. Then basically we are in a third world market bargaining for to receive translations and no longer in front of an international court. And with all due respect to Mr. President, Your Honors, I have to adopt this position as a proper defense counsel. I am not leaving this, my position because the court has asked me to do so, but just to say that I will come again and again requesting that translations be given. I am told that there was an order of the, an order on translation rights and obligations to the parties by the co-investigating judges, which basically said it wasn't necessary. That's not acceptable. I remember that there was a French king who once said, "I am the state." I don't think that that an investigating judge has the right to say, "I am the law. I am the one who can decide." We don't have the money to translate, ergo we shall not translate. Mr. President, Your Honors, your court is not the law, as that French king had stated. I am giving you a compliment. You can only be the humble servants of the law, and these are general principles that are accepted by all civilized nations. It is not a decision of the investigating judges. I did not want to take more time, and I have now concluded my submissions. Thank you.
So I would like to invite the co-prosecutors to make your oral brief submission. And please be reminded that you have 1 hour to make this submission, so please, this observation, so please divide the time among yourself.
Thank you, Mr. President. First of all, I would like to pay my respect to all the people in this hearing. My name, Jillian, is the national co-prosecutors, and my colleague, Mr. William Smith, is the co-deputy prosecutor, international co-deputy prosecutor. On behalf of the prosecution, I would like to respond to the appeal filed by the defense on behalf of Mr. Khieu Samphan, the former president of the Democratic Cambodia. My observation is that we divided into three sections. One, we have to respond to the translation which affects the right of the clients, and we also interpret the article 26.2 of the agreement, and my colleague will take over and explain the document which he can read, which he can understand, and his co-defense can defend his client effectively. Number 3, I will request the pretrial chamber to make a final request to the pretrial chamber. As you know that in the extraordinary chambers in the court of Cambodia, the office of the co-prosecutors has sent the introductory submission to the office of the co-investigating judge on the 18th July 2007, describing the details of the charges, crimes, imposed on this charged person and the other 4 charged persons who are responsible for the crimes committed in the period of 1925 to 1929. This submission was sent to the co-investigating judges to make the investigation and detain the charged person. And Mr. Khieu Samphan has been detained in the detention facility on the 17th November 2007 on the order of the co-investigating judges. In the proceedings, the co-investigating judges have the intention to interview the charged person, but the co-defense lawyers of the charged person refuse to answer or refuse to the request by the co-investigating judges, saying that as long as all the documents have to be translated. So on the 23rd April 2008, the co-investigating judges refused the request made by the co-defense lawyers that the season ordered all the parties, not only the co-defense counsels representing Mr. Khieu Samphan, but ordered together with the co-prosecutors when they sent to the decision to the offices to be translated, the priority of the document to be translated, and the defense team can choose a translator to translate within the 2 months. All the defense teams can adjourn the translation if required. And this is the decision was made by the co-investigating judges. On the contrary, the defense teams did not obey this decision, but in fact appeal against the decision, charging that the translation itself affects the rights of the charged person, his client, to get a fair and expeditious trial. This is a pretext to delay the trial. The delay itself affects the rights of the charged person to receive the fair and expeditious trial. So my submission is on the translations, on the rights of all the charged persons, including Khieu Samphan, standing before the court, the rights to be fairly tried and expeditiously. At the same time, we acknowledge our duties to interpret the law and other facts in aiming so that the pre-trial chamber can proceed. So we already submitted the written submission, the co-investigating judges, on the duties, rights and obligation of parties on translation, which has been appealed. Basically, it focused on the rights of the charged person to get a fair trial. This appeal began with the opposed opinion among the office of the co-investigating judges and the office of the defense teams on the translation of the current case file, which were submitted, and we would like to reconfirm the strategy. The strategy of many strategies, we haven't seen any support, basic support from the defense counsel. The argument is that the Jacques Vergès, the defense counsel, has had to receive all the documents of the case file which he himself can understand, who is the co-counsel, but it is not for the charged person. The law on the establishment of the ECC and the internal rules, including the Criminal Procedure Code of the Kingdom of Cambodia, and together with the case law in the international scene, do not support the position of the defense counsel. Numerous judges from various courts in an array of judicial systems have considered the same issue that is before this court, and not one decision has upheld the argument that a fair and expeditious trial can be achieved unless all documents are translated into the language of the defendant's counsel. This vast jurisprudence determines that there is no right to have every document translated into the language an accused understands, and even less so his counsel. The right to a fair trial and the right to an expeditious trial are inextricably linked. They can be translated in all as in the Internal Rule 26.2. In fact, the right to a fair trial does require the effectiveness. What effectiveness depends on? It depends largely on the important or particular documents to be translated. Number two, it's based on the permission to be translated when we have sufficient resources. When one court requires to translate every line of the document, then the proceedings cannot proceed. So it is on the contrary that the charged person would receive the fair trial and expeditious. So maybe the public and the court understand the word expeditious, what it really means. We see that, we also observe that problems occur in the international court which want to uphold the rights of the charged person to understand the types of the charges in order to defend themselves, despite they do not have enough documents, but it is when the document is available in a language the defendant can read and understand. The question is that whether the charged person is capable to understand the case file against him. Whether this, what is the original language of the case file? What is the source of the case file? Number three, the knowledge, language of the charged person, and the ability of the translators of the defense team, and the activity to participate in the defense teams in the process of preparing the case, the cooperation among the national and international co-defense council as stated in the Rule 21, the national co-counsel and international co-counsel have to cooperate closely in order to avoid any request like today's appeal. So the pre-trial chamber have to decide whether or not the accused is able to understand the case against him. It is, in fact, this is not an exclusive list, but it could be a list which is a fundamental, which the chamber has to consider whether the charged person is able to understand the case against him or not. Another point the co-prosecutors have submitted today is that, as already raised in our submission from our office, we would like to raise a number of arguments as follows. Number one, this appeal is, we cannot accept this appeal is inadmissible. Second, the charged person has access to and understands all the documents that he is entitled to as required under the ECCC and international law. Number three, even though some documents are not translated into all three working languages of the ECCC, the defense counsel is still able to effectively represent his client if he so wishes. And lastly, the translation order and the current translation status of the case file do not create an abuse of process against this charged person. Regardless, the remedy for such an abuse would not be the release of the charged person. I will make submission on the 4 points, and I already talked about the first point on the nature of the translation order and the most relevant sources of law to determine this appeal. And my colleague will make submission on points 2 and 3. Your Honors, the preliminary objection the co-prosecutor submit this appeal is inadmissible. It's about the translation order is not the type of order that can be appealed by the charged person to the pre-trial chamber. So please look at Internal Rule 74.3. It only allows the charged person to appeal orders to the pre-trial chamber which are listed in that rule. Appeals are limited to those orders confirming the jurisdiction of the ECCC, refusing requests for investigative action allowed under these internal rules, refusing requests for the restitution of seized items, refusing requests for expert reports allowed under these internal rules, refusing a request for additional expert investigation allowed under these internal rules, relating to provisional detention or bail, or refusing an application to seize the pretrial chamber for annulment of investigative action. These are the orders which could be appealed to the pretrial chambers. These grounds of appeal are exhaustive, which were described in 74. The internal rule did not mention, the rules does not contemplate an appeal by a charged person against an order by the co-investigating judges denying a request for the translation of every document. Nor do the rules grant a residual jurisdiction to the pretrial chambers, like, for example, 267 of the Criminal Procedure Code, which can be appealed by the co-investigating judges. It doesn't state about any appeal against the translation of document. When the document contains a language which the charged person can understand, the appeal against the translation can be refused.
Translation is a matter of judicial administration to the extent that it is managed by the registries of other international tribunals. Consequently, the present appeal against the translation order is beyond the scope of Rule 74(3) and should therefore be dismissed as inadmissible. Therefore, Your Honors, we submit that the issues relating to translations, although falling within the decision-making powers of the co-investigating judges, are not appealable to this chamber. However, if this chamber finds this appeal is admissible, it is submitted that it has no merit and similarly should be dismissed. Before responding to the legal basis of the order on translation rights and obligations of the parties, it is necessary to understand its precise nature. Unlike this appeal, which asks for an absolute decision from this chamber, the translation order balances competing rights to create a fair translation process. And rather than definitive inflexible outcomes as to the exact number of tie-up translations required prior to the commencement of trial, the order is in fact an invitation to parties to have translated documents that are important for them over and above the regular translation of documents being placed on the case file. Critically, the appeal, the order, does not lay down the translation rights and obligations of parties for all stages of the proceedings. So, in fact, it expressly states that the trial chamber and the pre-trial chamber, whom it cannot bind, may take such decisions that they deem appropriate. So the co-investigating judges notes that the pre-trial chamber needs to make sure that in the this matter is solved before the trial on the merit. The pre-trial the trial chamber ultimately needs to make sure that any proceedings is proceeded expeditiously, and the judges have asked all the parties, including the defense or the charged person, be given the adequate translation, of course, of the translation of the case files, including the full translation of the introductory submission or supplementary submission, and a translator is to be assigned to each section. The reason that a translator is assigned to the defense counsel is to make sure that the defense counsels can understand the matter at issue. Although when it comes to this translation matter, whether there is, of course, there is no any hindrance or to stop the counsel or the defense counsel from having this kind of translation being translated. And on the 7th of August 2008, the CMS sent the memorandum to the defense counsel of Khieu Samphan concerning the obligations of translation. And it can be referred to document A190. As your judges have already been familiar, the translation matter is very complicated, and parties need to understand different languages, and this is not new to us. Even in other international courts like the ICC court, the Yugoslavia and Rwanda tribunals, and the Special Court of Sierra Leone have all dealt with cases involving similar charges and have reconciled the right to fair and expeditious trial with the challenges of conducting proceedings in multiple languages. Domestic cases provide less useful assistance than international cases due to their smaller size and lack of complexity and linguistic challenges. Recently, other tribunals have dealt with and are currently dealing with crimes of similar magnitude with similar language issues. However, the defense argues that because the legal systems of these tribunals are different to that of the ECCC, the relevance of their jurisprudence regarding translation is questionable. With respect, the position is erroneous. First, it exaggerates the differences between the ECCC and these sister tribunals. Second, it oversimplifies the complexity involved when investigating and prosecuting large-scale criminal cases in multiple languages. And I think I would like to repeat that it is oversimplifies the complexity involved when investigating and prosecuting large-scale criminal cases in multiple languages. The defense argues that at the ECCC, the defendant participates in the proceedings much earlier than he does at these other tribunals. Therefore, they argue that access to translations of documents must be provided to a charged person much earlier than to an accused at the tribunal or sister tribunal, so that his or her participation can be effective. This position clearly fails to understand the importance of an accused's participation in the pretrial stage at the sister tribunals. Both here and at your sister tribunals, the pre-trial stage, the time an accused is in pre-trial detention at your sister tribunals is about the same length of time as a judicial investigation at this court. A charged person before the ECCC is in the same position as an accused before other international tribunals. Thus, the co-prosecutors submit that the rights of an accused are the same as the rights of a charged person. The obvious difference, of course, is that at the ECCC, the investigation phase is directed by an investigating judge, as opposed to the prosecutor at your sister tribunals. And this is the difference. And this is where the differences end and the similarities begin. In both systems, under the authority of the investigating judge or prosecutor at the pre-trial stage. And the defense counsel failed to value these similarities. And the rights of the charged person is entitled fully the principles that the international principles are applied. We submit that this chamber based their argument on the other jurisprudences of the other international courts, and there are no less than 17 references. Regarding the interpretation of Article 26.2 of the agreement between the United Nations and the Royal Government of Cambodia, and we observe that the defense lawyers raised this matter because the language to be used at the court must be English, Khmer, and French, and I think this article requires that all documents are translated in all languages, but I think this kind of reference should be rejected, because in the agreement not all the documents are subject to be translated fully, because as you know that there are 3 languages officially used in the court, but this does not require that all documents are translated into 3 languages. So this is the matter that faced by our chamber and other similar courts. I think we have found no other relevant jurisprudence regarding this provision. If the interpretation is correct, or were correct, then all the documents or from other meetings shall or should have been translated in 3 languages, or would have to be in 3 languages, and this would create an enormous requirement on the court, which would ultimately lead to wasted time and resources, exorbitant costs, and ultimately unduly delayed trials. Article 26.2 was never intended to provide a detailed prescription as to all the rights and obligations regarding translations. This interpretation by the defense, using only statutory interpretation principles on a broad agreement dealing with a complex issue, provides an inadequate solution. So, to conclude, it is submitted, therefore, that the jurisprudence from your sister tribunals is extremely valuable in determining whether they interpret that the phrase official working language means that every piece of evidence in each case must be translated in all 3 languages. And this is a question. And as is seen from our written submissions and will be seen from my colleague's submission in a moment, no such interpretation has been given to such a phrase in any of your sister tribunals. Next, as I already stated earlier, there are 4 points that I have or attempted to explain regarding the rights of the charged persons and the interpretation of Article 26.2 of the agreement. And I would like now to share this floor to my colleague to elaborate further on the matters, and we will briefly present the evidence that the prosecutor submitted to the pretrial chamber regarding this matter, whether to prove that the defense counsel must have been quite familiar with these cases. We would like to have 15 minutes break before we resume. We would